So it would not surprise me that on something like this, a similar briefing would occur. But I have no personal knowledge of anything that deals with briefing. We were just doing our job. I mean, we were just line attorneys collecting evidence, making phone calls, writing pleadings. So all of these other issues are not my issues.
Sure, but you did, I think, answer, and I want to make sure I got that right, that in your knowledge, the department has never refused to pursue a default judgment.
Well, in my knowledge, and if Coates was here, his knowledge goes back further.
Okay.
So,
and I'm just trying to get your general knowledge, whether that supports former Associate Attorney General Katz's, that it's unlikely that political acting officials like King and Rosenbaum would have been able to make the final call in the department to dismiss the suit.
my your is that former associate or acting associate and former assistant attorney general Katz's gave testimony that is consistent with your conclusion.
Well, let me, since you have briefed the associate before, their interrogatory answers from the department say that Pirelli, the current associate attorney general, was briefed about the case and the potential dismissal. It also said the attorney general was made generally aware. In your experience in the department, does the attorney general and associate attorney general have the authority to express an opinion?
I would hope so.
If they're being briefed on a matter, can they ask for more information if they want more information?
I've been given requests for more information from one of those offices you named.
Okay. And those offices are generally briefed about a matter so that they can take contrary action to the proposed, that they can say, yes, your proposed action is okay, no, I don't want you to do that. They have the authority to do that within the department, don't they?
I assume they do, but again, I'm a line attorney.
Last question.
Okay, that's fine. I'll yield. Thank you.
Commissioner Kirschnau.
Thank you, Mr. Chairman. Mr. Adams, longtime civil rights attorney Bartle Bull, who was a witness in this case, expressed the opinion that this was the worst case of voter intimidation he's seen in over 40 years. Do you assess that? Do you concur with that assessment?
Well, I haven't been around as long as Bartle Bull has. He was in Mississippi in the late 60s. He worked on Charles Evers' governor's campaign. He was Jimmy Carter's campaign director. He was Robert F. Kennedy's. He got a medal from the Lawyers Committee for Civil Rights recently for his work. He's been around a lot longer than me. So I cannot corroborate his wisdom because he's just seen more than I have. Nor would I disagree with it.
The Vice Chair, who's not here today, has a piece on National Review Online today in which he makes light of the fact that there were only 2 Panthers involved in this case, in describing this case as very small potatoes. Does the number of potential defendants have any bearing on whether or not 11B charges should be brought by the DOJ?
It can have one defendant. It doesn't matter. If you break the law, you break the law. You know, if I might for a moment, the absent commissioner is a friend of mine. And she wrote a book, which I highly recommend, called Voting Rights and Wrongs. I suggest that this commission introduce portions of it into the record because it corroborates much of what I'm saying. She has a whole section on page 124 called A Lawless Civil Rights Division. She has descriptions how, on page 130, that the Civil Rights Division from 93 to 2000 was forced to pay over $4 million in attorney's fees and costs awarded against DOJ for filing frivolous and unwarranted discrimination cases in 10 lawsuits. There's a whole lot more in her book that corroborates what I'm saying today. Not specific facts, but the general culture. And if basically from page 113 to 145, Commissioner Thernstrom, who's a friend, speaks about what I'm speaking about.
The Vice Chair also makes mention of the fact that these actions were allegedly performed in majority black precincts. Should that have any bearing on whether or not 11B charges should be brought?
Well, the relevance to whether they were performed in majority black precincts shows up in a couple different places. One, you won't want to be that 10% in the minority in that particular precinct with a Black Panther there. And that's exactly what it is 10% white in that precinct, according to my best estimates. It's probably plus or minus 3. So yes, it has some relevance, but it shouldn't drive the question. The fact that it's a majority black precinct in Philadelphia is a preposterous way to oppose going forward in this case. It's saying, you know, the numbers are too slim. You're only a few people, so you don't deserve federal protection.
The salient time frame for dismissal of this case was sometime, I believe, between April 29th of 2009 and May 15th. April 29th, Mr. Rosenbaum expresses some doubts as to whether or not this is a strong case, and then on May 15th, the trial team is ordered to dismiss a portion of the charges and reduce the scope of the injunction. Are you aware of, and I'm not asking for anything that's privileged or any detail, but are you aware of whether or not any facts in the case changed in that time frame?
What was your first date?
April 29th of 2009 through May 15th of 2009.
No, no publicly available facts about the Black Panthers, about this event, changed whatsoever.
Did any aspect of the law change? In other words, were there any decisions rendered by any federal court that would change the interpretation of 11B as applied to the facts of this case?
Nothing.
In that 2-week period, are you aware of any opinion, facts, evidence introduced by any individual, group, branch, section of DOJ that would affect the outcome in this particular case?
Well, you're asking me about possible internal deliberations, and I won't answer that question.
Okay. Getting back to the description of this particular case as very small potatoes, in your experience, would the new Black Panther case be considered very small potatoes?
Well, certainly not when you, if somebody were to get to the bottom of when this really started, was it going on during the primaries or not, that would become very big potatoes. But even putting that issue aside, we in this country, I believe, still recognize that the ballot box is sacred, that there is something exceptional about this nation that values the right to vote. We've shed so much blood to get here. And we've shed so much blood to get here, and it has to be treated with absolute sanctity. And so it doesn't matter if it's one person with a stick, or 5 people with a gun, or a bunch of people in Philadelphia, Mississippi with a deputy sheriff named Cecil Price working for him. We have an ironclad obligation in this nation to protect the right to vote because so many people died to get us here. And so I think the argument that it was only one person doesn't matter, because one person is the next person, and then more. And, you know, we had evidence that this wasn't necessarily just isolated. So the idea that you wouldn't pursue this because it was only one person is what an apologist does. And that's what the SEGs did in the 60s.
Thank you.
Thank you, Mr. Chair.
At this time, Mr. Taylor.
Thank you, Mr. Chairman. You have 5 years of experience in the voting rights section, correct?
That's correct.
During that time period, was there any other instance in which the division or the department, to your knowledge, walked away from a default order and did not ask the court to enter a default judgment for all of the relief requested in the original complaint?
No, in fairness, though, this doesn't happen. The mere fact that there was a default was an anomaly in this case, especially when one of the parties had counsel, and one of the other parties was an attorney.
I want to follow up on Commissioner Kirstenau's questions in terms of the law not changing during the critical time period and the underlying facts of the case not changing. Once the court entered its default order on April 17th, we have our memo here from Diana Flynn dated May 13th. Were you aware of this memo's existence during this time period?
During this time period, generally, yes.
You were aware of it?
Yeah.
Did you actually see it?
Yes.
So you were aware that she said, and this is Diana Flynn, who is in the appellate section, sort of the second review, if you will, of your work and whether or not you all should proceed for a default judgment. We have already brought the case and made the allegations, and she says, see the complaint. And I assume that this reflects the division's policy judgment that it is appropriate to seek such relief after trial. She's talking about the relief requested in the original complaint.